Okay, I'm Leonard Lang, and this posting will go under CalReg Solutions. And we want to talk about California's regulatory environment and things that are wrong with it. One of the things that's wrong with it is the legislature has given state agencies, I don't know how many, but I know it moves across more than one, an ability to use a function known as an informal hearing. The informal hearing is a form of adjudication that was designed to discipline college students and state employees. It was never intended to be used for businesses. It should not be used for businesses. Businesses have a completely different set of circumstances. They have legal obligations that they have to fulfill, and they can't be subjected to the whim of an informal hearing. Now, the informal hearing is something that allows the director of a department or agency to hear a grievance or an accusation against a regulated entity, person, business, whatever. But it also, in statute, allows him or her to delegate that responsibility down into the organization. So let's use CalRecycle as an example. In CalRecycle, enforcement comes up with the accusation along with legal, and if the recycler contests it and requests an appeal, it goes before a hearing. The person who's going to hear that is the trier of fact, a legal term, is a fellow attorney. And the question is, do they have an undue bias that since they come from this agency, and this agency wouldn't do anything that the boss didn't want them to do, and they have the same boss, don't you think we'd find that in favor of the department the majority of the time? You will. And it doesn't matter about the facts. It doesn't matter about the regulations and the statute. There is a bias. If we were to have an audit of these procedures, it would come out. The government knows how to evaluate itself. An audit would show what they're doing wrong and hopefully give them the prescription on what to do in the future. But as we've seen with CalRecycle, they continue to do what they want. Another area we find the informal hearing is in weights and measures. And again, they tend to side with themselves. I've been through several of them. Doesn't matter. The accuser admitted to making mistakes sometimes, but we don't go on a basis of beyond a reasonable doubt. We're on a different standard for justice, and that standard is too low. So if you're regulated under a program that allows for the informal hearing, you need to know this. You need to know how unfair it is and how you shouldn't want this in your laws. Get it out, get before an impartial judge, which you'll find in a thing called the formal hearing. So we don't want businesses subject to the informal hearing because it's not a good process, not a fair process, not subject to bias is what we want. So that's the informal hearing. That's CalReg Solutions. Change the statute, get those out of regulations, and we can move on to a fairer, more impartial system within California. I thank you.